Welcome to James Hates Everything. This is a channel where we talk home arcade, retro gaming, toys, TV, movies, all things nostalgia. And today we have to get into Arcade1up. We've talked previously about the conflicts that they've had with a former contractor, Thinkup. And today we have lots of documentation from a new lawsuit filed by Thinkup against Arcade1up. And we are going to dive into the nitty gritty, go through those documents, and get an inside look at what Arcade1up is doing like never before. So let's get into it. All right. Thank you, everybody, once again for joining us. And today we are talking about Thinkup versus Disruptive Products, aka Tastemakers. Earlier this year, around the beginning of the year, Tastemakers, sorry, Thinkup filed a objection to a trademark filed by Arcade1up on the Infinity Game table and Infinity Game board. In that filing, um, Thinkup alleged, "Hey, those are our trademarks. You can't use them," et cetera, et cetera. Then, sometime around February, and actually, uh, yeah, in that February timeframe, Tastemakers filed for an extension to respond to the complaint by Thinkup. They asked for a 30-day extension, citing that they had hired new attorneys. Then in March, towards the end of March, Thinkup filed a voluntary dismissal of their objection, and it was subsequently dismissed without prejudice, which means Thinkup could leverage that complaint again if they wanted. Well, we have, um, ideated or, um, you know, contemplated the reason behind their voluntary re- re- revoke or dismissal of that complaint was that perhaps they released some sort of settlement with Arcade1up. Well, now we know, based on current court filing as of the end of April, that that is not the case. Instead, what ThinkUp has decided to do was instead file a lawsuit against Arcade1up. And as you can see here, this lawsuit has been filed in the Superior Court of New Jersey, Camden County specifically. And so we're going to go through this complaint together and read through it. And I've highlighted a few sections. We're also going to take a look at the exhibits in this complaint, which will provide further information within the inner workings of the company. And I'm not going to read everything in here. I've highlighted a few sections, but there are some key things we need to talk about up front here, right? First up, who is ThinkUp? So ThinkUp is our plaintiff in this case, and they are a company that designs toys. Um, they do R&D, they do development, they do all kinds of things. They're essentially toy designers. I don't know how else to put it any other way as clearer than that. They are based in New Jersey. And of course, our defendants in this case is Disruptive, aka Tastemakers, aka Arcade1up. And they are based principally for a corporation in New York, though they run their company out of Miami. Um, so here's the statement of facts. So this is where it gets in. ThinkUp is a design studio, product development. So we won't go into that. There's ThinkUp's logo. We'll start here with the relationship, and of course, ThinkUp is founded by its president, Jerry Cummings. So that's important to understand. He's the principal through all this as we get through a lot of this. So as we dive in, let's take a look at the history of ThinkUp and Arcade1up. And it says, in the early 1990s, ThinkUp began working with Scott Bacharach, on a number of projects involving the development sale of toys and games. In each case, the parties worked purely on a handshake arrangement, with ThinkUp being the responsible for the development of the concept, design, and artwork for the project, and Mr. Bacharach through his various companies providing the manufacturing, marketing, distribution of these products in each of the parties. In each case, the parties agreed that ThinkUp would receive 3% of sales revenue for the life of the product. So, little to unpack here, right? So, they've had a long-standing relationship going back, at this point, close to 35 years. Um, the uh, the interesting thing here is you have a history of doing deals with handshakes. Uh, which is not advisable, right? If you were going to start a business, if you're going to conduct business, even if you're conducting business with a relative, you should have some sort of legal document governing that relationship. It is for your protection, it is for their protection. Failure to do so is just a recipe for disaster, as we will see. So let's move forward a little bit. While ThinkUp's New Jersey in office, Mr. Cummings, and this is around in 2017, right? Mr. Cummings showed Mr. Bacharach a foam core mock-up of the original idea of what would eventually become Arcade1up's line of three-quarter scale retro arcade games. Mr. Bacharach was impressed with the concept and mock-up created by Mr. Cummings, and the two shook hands and agreed to work together on bringing the idea to market. Similar to the prior projects, the parties agreed that ThinkUp would develop the arcade products in exchange for 3% of net sales revenue for the life of the product. And Mr. Bacharach, through his company Tastemakers, would secure the necessary licensing and otherwise bring the products to the marketplace. So here, basically, what we see is that ThinkUp designed the entire product from basically the ground up. They came up with the naming, they came up with the different cab designs, they came up with the the whole, and we'll get into this a little more detailed as we go. And Tastemaker's side of the deal was to go hunt down those licensing, secure the licensing, and secure the relationship with wholesalers and retailers in order to get these products into the marketplace. The remaining part of this is just going over that, hey, ThinkUp made some investments in order to bring these things to life. It says ThinkUp named the product Arcade1up. So that's again is a brand and logo created by Arcade1up, and they provide a sample here. This is the Arcade1up at home arcade logo that they came up with. It talks here about Mr. Cummings traveling to China to find manufacturers to put this together. And so, as we get into this, ThinkUp is stating that they have created every facet of the products, including logo, animations on startups or animation screens, the entire user interface, graphics, control flow, and they even designed the retail packaging for all the products. So basically, they're stating here they've done everything except for the licensed game themselves. That was all developed by ThinkUp as a contractor to Arcade1up. It says ThinkUp developed primarily packaged its parts for transport and retail sales, making them easy to assemble at consumers' homes. Produced the instruction manuals in multiple languages, and they provide, of course, a sample of one of those instruction manuals. They talk about going through design meetings in Hong Kong. They created some, sizzle reels for social media. They also participated in all trade shows. They designed the trade show setups. They traveled to those trade shows to market Arcade1up. They also participated in meetings with various potential retailers. Here they call out Walmart specifically. And they expand. The role of tastemakers was threefold. First, secure the licenses for the entities from the entities who control the rights to the arcade video games, which will be to converted into home arcades such as Pac-Man and Space Invaders. Second, Tastemakers is to contract for and finance the manufacturing of the Arcade1up machine. So they are also responsible for finding all the money in order to produce the products. And third, to manage the marketing and distributions of the products, both wholesale and retail. This goes back to their responsibility to find wholesalers and retailers to deliver. Sometime near the end of 2017, Mr. Bacharach informed Mr. Cummings that he had negotiated an order for 100,000 Arcade One Up machines from Walmart, together with a letter of credit from the retailer to secure the payment to manufacture. So, this is the first time they have their first big order. And to finance the manufacturing of those games, Walmart agreed to foot the bill. And then it says in February of 2018, an important aspect of the handshake agreement between Tastemakers and Thinkup was confirmed in an email, a copy of which is attached. In that email, Mr. Baccarat confirmed Thinkup would receive the parties termed 3% royalties for each Arcade One Up product for its life. And we, of course, have a copy of that email here. You can see it is dated February 15th, 2018. This is Jerry Cummings sending an email to Scott Bacharach and says, hey, he has a few comments. One, the royalty of 3% is for the life, in this case, the like of the product. And you can see Scott Bacharach here agrees. Jerry also states he understands that $20,000 a month in the 1M line, but I want a 7-month limit. So October would work for us to talk. Not 100% sure what this is referring to, but Scott Bacharach agrees. And then he has a third question, reducing my royalty this year. So apparently Scott had asked him to cut back the royalty to help them get started and get moving. Actually, this is 2018, so maybe this is an expansion as the popularity took off. He says, this is a big ask. And I think what you'll see is this is when they start getting investor interest. And so some of this may play into that. He says, this is a big ask. I can see you asking this to others, but I'm the lightning rod that is making it so everyone can make a lot of money. I'm a little hurt and not sure how to take this. So he points out that he's basically insinuating here, hey, I'm the one who came up with all this stuff. This is my idea. I'm the reason we're going to make all this money. Why do you want me to take a cut? And Scott responds, you and I are both lightning rods, but at this point, I'm shouldering all. It's a real $8 million loss for me, and I'm still paying all. So I'm not sure what he's referring to there. So apparently they've lost $8 million that year for some reason. It's unclear what that is. He says those that make big also take the hits. So he's saying, hey, you've heavily profited. I've heavily profited. So we're going to have to suck it up and shoulder the loss here, whatever that $8 million loss is. He said, I think you should help. If you do not, you do not. So stop being a baby. So here's Scott even saying, hey, like, look, it's you're making lots of money. We think you should shoulder part of that. But if you're not, hey, whatever, we'll move on. And of course, he says, stop being a baby, LOL, showing I guess they have a pretty cordial, friendly relationship. So as we jump back over, now production has commenced uh, on the first machine. So all this $8 million lead up is probably all the costs that they've done to ramp up to bring development costs on the first products, hiring staff, securing offices for Arcade One Up. So you can see a lot going into it. So that's probably what that $8 million is. So he's asking, Scott is saying, hey, we've invested this $8 million. I need you to let us recoup that or portions of that uh, as we move forward here and start making bank. And of course, commenced and the first machines were delivered to Walmart with fanfare. He talks about receiving the Toy of the Year award at the New York Toy Fair, and receiving their first payment from Mr. Bachrach of $500,000. And so later in 2019, Mr. Bachrach af- advised the company's investors advised that the company's investors required a written agreement to confirm the hitherto oral arrangements between the parties. So up until this point, Thinkup and Arcade1up were still doing everything on a handshake with no written contract. Arcade1up is now excuse me, now receiving a significant financial investment, and we know of this investment. It came in the terms what it possibly appears to be in the terms of a loan. In obviously there was exchange for equity, and it may not have been just a loan. There may have been a large capital outlay as part of that investment as well. But this is where we see the investors really coming in and forcing Arcade One Up to do some of the things they want. So this is where we get into the largest mistake that ThinkUp makes. And he said, they state here, unfamiliar with the legal documents of this nature, Mr. Cummings asked Mr. Bachrach if the agreement provided his company with 3% royalties for the life of the products. As agreed, and Mr. Bachrach assured him it did. Based on the assurances, Mr. Cummings signed the 2019 Arcade One Up agreement on behalf of plaintiff. So wow, um, this is a massive, massive mistake in my opinion. And again, everything we're talking about here, I am not a lawyer. Don't take this as legal advice. This is your disclaimer. Um, not legal advice. We're just going to talk about this. I have opinions based on my time in business and negotiating contracts and working with attorneys on these things that I will share with you really starting now. But it is not legal advice. Don't take it as legal advice. This is a YouTube channel for entertainment purposes only. And all opinions are my own and shouldn't be construed for YouTube or anybody else. Yada, yada, yada. All that fun disclaimer stuff, right? So never ever, even if again, I'll fall back on this, even if it's your friend, your brother, your sister, your mother, your father, whoever, it doesn't matter what the relationship with somebody in your business, you need to have somebody on your side, especially if you don't understand the legal terms. And I would argue, even if you do understand the legal terms, you need to have representation. You need somebody to review those documents who has your best interests in mind. Because believe me, Arcade One Up and Tastemakers and their investors did that on their end. And as we look at this agreement that ThinkUp signed, you will see how completely and utterly one-sided this agreement is, um, and how little foreshadowing how what a tough position it puts ThinkUp in this argument. So the next several sections here, he's talking about the contract itself, and he has questions around it. Um, States that they were all signed. He says the 2019 Arcade One Up agreement provided that ThinkUp would serve as the company's research and development team for the Arcade One Up brand, focusing on product category definition, working with manufacturers in Asia, and assisting with pitch meetings with licensors, potential customers, and otherwise bringing products to life. And we will review the entire agreement, but here he's calling out commissions. This is the section that says during the term of this agreement, this is the first line, right? During the term of this agreement. So what that means is anything that follows is only in effect while this agreement is in effect. So that's key to remember for later. So during the term of this agreement, and as compensation for all services provided by developer hereunder, company agrees to pay developer 3% of worldwide net sales as hereinafter defined. Made net sales made, shipped, and distributed to customers on orders which have been approved by the company and which have been obtained by the developer. So again, During the term of this agreement, you get three tastemakers, or sorry, ThinkUp will get 3% of net sales on all orders that were made, shipped, and distributed to customers, again, during this agreement. So, whereas the email we saw earlier stated for the life of the product, now we're seeing it's really for the life of this agreement. Life is not spelled out in the email, but here in written contract language, it is clearly being defined as the term of this agreement. So as we move in, of course, they talk about the royalties slash commission, and ThinkUp says the use of the word commissions instead of royalties suggests either parties believe they were synonymous or simply that the change may have been an inadvertent error. Here he's speaking simply to the word commission, which is a heading in the contract, which is just a heading to get you to the royalties section. It is not it is not a legally binding term for the agreement. It is just a heading, and you'll see even in the contract itself, it specifically states the headings are just for label purposes and have no contractual validity. So what matters is that sentence about the 3% royalties for the life of the contract. So ThinkUp considered the payments royalties, and the ThinkUp is providing access to intellectual property that it had and would be creating in connection with Arcade1up brand. So it's just saying they're just clarifying here that they believe these are to be royalties and that they are their property, intellectual property. In paragraph 6A, it now speaks about the right of termination and says, if the contract or agreement is terminated, at termination, ThinkUp will continue to receive commissions on all Arcade1up machines which have been completed. However, it will not be entitled to commissions on machines that are in the development stage and not completed at the time of termination. So again, here we go back to this that they were time boxed this entire agreement around the life of the agreement. So they're saying if the product was in development and never came to order or to market during the term of the agreement, then those products, they don't owe any commission on those. So if they come out after the agreement was severed, those are 100% just Arcade1up's revenue. And as you know, as we get into this, most of the products that were released in 2023, of which there were many, over 14, if you count the Infinity Game Board, you're looking at 15. Those occurred mostly, not all of them, but most of them in Q4, which as you will see is likely most of them are post sever of this agreement. So that's interesting to note. Uh, and then he talks. They allege here that there's more confusing language. This one specifically says developers shall be entitled to commissions in according with the provisions of this agreement on orders written up to the effective date of termination or expiration or such other length of time as agreed to in writing by company and developer. All such commissions on orders shipped within 60 days of order date shall be considered earned in accordance with the foregoing and shall be paid in accordance. So they're saying if they get an order up to 60 days after the termination of the agreement, then that's still considered within the term of the agreement. So this expands what ThinkUp would earn, which again, as we talked about, that termination date of the agreement would pretty much cover them through most of 2023, right up through towards the end of Q4. So again, we may see, most of the Q4 sales and all of 2023 sales essentially would be owed to ThinkUp. Nowhere in paragraph 6D or any other paragraph of the 2019 Arcade1up agreement does it provide that ThinkUp is not entitled to receive royalties or commissions for sales of Arcade1up machines after termination. Instead, the various sections address the payment of commissions on sales and orders during the term of the services, And paragraph 6D further acknowledges the potential commissions to be payable for such other length of time as agreed to in writing by the company. So again, this is you can see that Thinkup here and their attorneys are trying to set up that, hey, we previously agreed that it would be for life, and life in that email is not defined. And so therefore they're alleging, hey, we have something else in writing that says you would agree to pay these royalties indefinitely. So what is life? Is it the life of uh, think think one think up's CEO Jerry? Is it the life of the product? Is it the life of the agreement? Well, there's nothing in that email that tells us what the life is. However, we do have a signed agreement by both parties that expands and defines what life is, and it is specifically the term of the agreement. So ThinkUp now has themselves in a pickle because they have signed an agreement after that email in which they agreed that the term is the term of the agreement. So, in my opinion, they are going to have a really tough time arguing that it's the life of the product based on the fact that they signed this other agreement. Again, really good reason why you should always get your own representation in any legal matter and when it's signing any contract. They allege at best there's inconsistency between the various paragraphs, ambiguity that could be resolved by the admission of the prior written oral statements between the parties. So again, they're alleging that it's unclear. I would argue that the terms, in my opinion, are very clear in the contract, but they need this ambiguity to exist in order to bring the email into their argument and to argue against the terms that ThinkUp signed. I think that is uh, going to be difficult to convince a judge to allow that in, but who knows? Says neither Mr. Bacharach nor any other representative of the defendants ever explained to ThinkUp the difference or relationship between defendants. So here's saying, um, there is a few different companies listed on this as defendants in this case. One is Disruptive Products, the other is Tastemakers. So here they're stating we have no idea and nowhere is it explained in the agreement what the relationship is between Disruptive Products, Tastemakers, LLC, and that again is confusing because who's their agreement with? Is it with Tastemakers? Is it with Disruptive? Where's the relationship? Which is smart to bring that up. In all communications between the parties, with the exception of the 2019 Arcade1up agreement and the 2023 letter terminating the contract, ThinkUp dealt exclusively with Tastemakers, and it was Tastemakers that wrote checks and wired monies to ThinkUp. It is therefore unclear as to what the role of, if any, Disruptive truly plays in the development, manufacturing, and distribution of Arcade1up line of products. Most likely, this Disruptive Products is a holding company. And the purpose of that is to limit the liability of investors and shareholders. So this Disruptive Products likely owns Tastemakers LLC, which then, of course, is operating the brand Arcade1up. So if Tastemakers LLC ever fails, sues, whatever, that liability is limited to Tastemakers LLC and not all of the assets under control by Disruptive Products. But without seeing those agreements, without seeing the corporate structure, it's just a guess. But that's seems to be what it is. It would be nice to get some clarity on that, and perhaps we will see that if there are any responses to this filing in the future. I suspect there will not be, and we'll get into that when we talk about the agreement specifically, because there are some provisions in that agreement that make me think that this lawsuit, as filed, will likely get dismissed on a summary judgment, meaning before trial and ThinkUp, if they want to proceed, will likely have to refile in a different jurisdiction. But we'll see. Courts can do a variety of different things. There may be some laws within New Jersey where this was filed uh, that get around that. But in short, both parties agreed that any dispute, legal or otherwise, uh, governing this agreement will be filed in the District of New York, not in New Jersey. This lawsuit was filed by ThinkUp in New Jersey, which is not the location that both parties agreed to. So, in all likelihood, it may not go forward. But as I mentioned, it's subject to whatever New Jersey laws are there that are governing that. Again, I'm not an attorney. It's just what I've learned and read through other cases and stuff I've followed from that regard. So uh, they also state here it's unclear what revenues. So they're alleging that they have no idea what sales of Arcade1up machines were. I think you will find that that's probably not accurate as well. It's potentially accurate. We don't have enough information, but we do have a document that provides that breakdown at least for 2023. And so if they were delivering similar reports, we do know what sales were. And then it's such sales, and it says, according to conversations Jerry Cummings had with Tastemakers employees as well as with Mr. Bacharach. So this is where it gets interesting. And if these numbers are true, holy cow. So ThinkUp believes the total revenues during the term of the 2019 Arcade1 agreement alone may have been in the range of 500 million to 750 million. $750 million in the span of 4 years. Because remember, this agreement covers 2019 through roughly September of 2023. So in that time period, they're alleging that they believe Arcade1up sales were $500 million to $750 million. So forget everything we've estimated about Arcade1up sales, and of course we have documented data coming up that will show we need to forget everything we've heard about Arcade1up sales. If Arcade1up's debt is only in the $20 million range, they should have no problem paying that. But I suspect something else is afoot, but we will get more into that. So which should have generated royalties to ThinkUp of more than $20 million, yet ThinkUp received close to half that. So ThinkUp here says they've received $10 million in commission. So 10 million. If they've received $10 million and that's 3%, right? You do the math. That means Arcade1up had 97% more. You're talking, again, close to $1 billion in revenue. Uh, just that's just unfathomable to me that they're hitting that size of revenues, but it appears that is accurate. It's just completely mind-boggling. In or about February 2019, Mr. Cummings, on behalf of ThinkUp, contacted Mr. Bacharach, and actually, I just did fuzzy math in my head, so let me actually get that correct. So 3%. Get the trusty old calculator here. We'll do 10 million. Yeah, so that's close to $333 million. So not a billion, a third of $1 billion. But they suspect it's higher than that. But even at a third of $1 billion, 333 million, that's a lot. But 20 million comes in, 6% of that number. If we estimate that's what Arcade1up still owes in debt, who knows? It's probably much higher than that. But again, no facts and evidence for that. um, then okay, so now we're in February 2019, and ThinkUp contacts Mr. Bacharach with a new concept. Here we find the introduction of the Infinity Game Board and the Infinity Game Table. We run through talking about what the Infinity Game Board is. Of course, it's a touchscreen game board. They talk about the concept consisting of two components: the hardware touchscreen, as well as the software, which is the games themselves, the user interface settings, and the subsequent game store in which people can buy and download additional games to the game table. The Infinity Game Board thus differs from all the other Arcade1up products is that it creates dual revenue streams. Not only do you have the sale of the hardware, but now you have the revenue for purchases of the board games through the game store. So similar to Arcade1up line of products, the original concept for the Infinity Game Table was the sole brainchild of Mr. Cummings and ThinkUp. Again, Mr. Bacharach was impressed with and excited about the concept created by Mr. Cummings and ThinkUp, and was anxious to partner with ThinkUp in order to bring the Infinity Game Table to market. In the Infinity Game Table is an entirely new kind of product which had characteristics different from the Arcade1up line of products and included multiple revenue streams. ThinkUp presented it to Mr. Bacharach with the understanding that separate agreements would need to be struck with Tastemakers, which was the only company with which ThinkUp interfaced. And again, you will find the agreement that ThinkUp signed with Tastemakers does not back this claim up. Wow. And we'll get into that in just a little bit. So in 2019, Arcade1up dated 5 months and first introduced. So he's saying they signed the agreement in 2019 before Infinity Game Table was even told to Bacharach. So they assumed that they should have a separate contract. And again, another mistake by ThinkUp says relying upon the parties' long relationship and mutual trust, ThinkUp moved forward with the development of the Infinity Game Table concept while continuing to discuss the terms of the agreement of the new product line to include a similar 3% royalty in all sale of hardware and a fair market split of the revenue generated by the sale of additional games developed by ThinkUp through the Infinity Game Table store. So here we see an opportunity, because as we look at this contract, you will see the contract is wider here than what ThinkUp will allege. And so if they were in discussion with Arcade1up for a separate agreement, they did not provide any evidence to that effect in this filing. And so that will be something that they'll need to produce as part of discovery if it ever gets that far. Of course, he talks about the countless hours they spent developing the Infinity Game Table. They show the Infinity Game logo. Here's an interesting thing for Infinity Game Table fans, and it says that ThinkUp designed the physical table board in 3 sizes, having widths of 19, 24, and 32 inches. So here we are going back to the original design, and currently Arcade1up has both the Infinity Game Table and Infinity Game Board in market, and it seems both of those products were designed at the same time and planned for. So the Infinity Game Board was not something they developed later in response to customer demand. It was always in the wheelhouse and always planned as part of a product. Now, they may not have planned on released it and just chose the larger one, which they say proved to be the most popular, which was sold with legs, and they show the picture of that below. But the game table itself was already planned and developed. Now, one of the interesting things here, it says ThinkUp works with third-party developers to create a digital version of those 16 classic Hasbro games. So potentially not direct ports of the Android versions of those games, or they are, and ThinkUp just licensed those from those. It's unclear. But basically, they went with them and had them developed for the game table. ThinkUp themselves also created 29 original games for the game table. It says by the time it was released, ThinkUp had completed the design of 50 games to be included with the original unit at no additional charge to the customer, along with original screensavers, which would run on the unit. And of course, they provide some samples of that development work in those screensavers. And here's a few examples of the games that ThinkUp created. And then the complete list of games. And they say, with respects to sales from the game store, the parties agreed that third party developers would receive the industry standard 70% of the sales price of the game, with 30% retained by defendants, less the 3% royalty commission payable to ThinkUp for revenue. So here they're saying they're basically following the Apple Store model that if you develop a game for the Infinity Game Table, you get 70% of the revenue. Tastemakers would keep, or Arcade1up keeps 30%, but they still need to pay 3% to ThinkUp as part of that royalty. So that 3% would come out of Arcade1up's side, not on the side of the developer. And they note that currently there are 32 third party creators, not counting ThinkUp, in the store receiving commissions from Arcade1up. And so that may account for some of their financial woes. If they are having financial woes, they're having to pay all these developers. Who knows how many refunds and stuff they have to issue, things like that, from kids accidentally ordering games that their parents didn't approve them to. Anyway, so ThinkUp created 37 unique games offered for sale in the game store for which it has not been paid commissions to date by defendants. So that's interesting. So they're here alleging that they are an independent third party developer and should get 70% of those sales. But I think, as you will see, their agreement so open that that is not accurate. So I think this is them thinking this, that they believe this, but don't have anything to back that up. And again, unless they can produce some other documentation which has yet to be produced showing that they should have received that. What they filed with this lawsuit does not say that. So then they talk about reporting of sales, 3% net sales, blah blah blah. To better manage cash flows, Tastemakers began paying ThinkUp a fixed monthly amount subject to reconciliation at certain intervals. So here they're saying, hey, we don't have the cash because it's still coming in. So we're just going to pay you X dollars. And then we'll every quarter get back together. I think it said every quarter. It says certain individuals, but it appears to be quarterly. We'll get back together, reconcile, and then we will either pay you the difference or you'll pay us the difference, kind of a thing. So then after July 2023, without notice or good reason, so this is the date, July 2023, Tastemakers stopped sending ThinkUp its 3% commission for sales of either the Arcade1up or Infinity Game Table line of products. So this seems to be the date. This July date is when everything changed over at Arcade1up, right? It's the stated date that John D left, that Scott left. This is where they all disappear. And so suddenly Tastemakers stops making payments to ThinkUp, their largest customer. On August 10th, ThinkUp receives a call from Davin Sufer, sorry if I pronounced that wrong, the COO of Tastemakers. Mr. Sufer advised Mr. Bacharach had resigned from defendants because of financial reasons, but their relationship with ThinkUp was still valued and the agreements with ThinkUp would be honored. So here you have specifically stating what we all assumed, that Mr. Bacharach stepped down as CEO or was asked to step down because of financial woes within the company. Mr. Cummings was also asked to attend a meeting on August 16th in Miami to discuss how the parties would proceed without Bacharach. So this is interesting because it's somewhat contradicts what he says in the first line. Says the same agreements would be honored. Which two, why do you need to have a meeting to discuss how they proceed without Mr. Bacharach? Um, I guess you could argue it was just a new uh, communication flows, things like that. But uh, the two actions to me, with the limited information I have, seem to contradict each other. But at that meeting, attended by Dora DeVere, later understood to be the CFO of Disruptive, but having an email address of Dora at Tastemakers LLC, and an individual named Mackenzie Shea, later identified as Chief Restructuring Officer of Disruptive. This Mackenzie Shea is also um, seems to be a consultant that does judiciary consulting for businesses. So somehow she also has the title of Chief Restructuring Officer at Disruptive. Maybe she is also permanently employed there as part of that. And this again goes into that holding corporation. So this disruptive corporation that maybe owns Tastemakers is familiar with the financial woes of the investments in the startup companies they invest in. And they have a full time chief restructuring officer to deal with when those companies don't perform up to what they were intended. Again, all just ideation, but chief restructuring officer is a very unique title. The fact that she is also a contractor for a big business consulting firm is interesting. So defendants changed course and advised Mr. Cummings that they would no longer honor the agreement to pay Thinkup 3% of the revenues received from the sales of Arcade1up and Infinity Game Table product lines, or any other compensation except possibly for some future drawings if needed by defendants. Blindsided, astounded, and confused by the news, Mr. Cummings reminded those in the meeting that he and his company were principally responsible for the very existence and success of the products, and insisted on receiving what was agreed to be paid in advance of their development. So here what you see is the restructuring officer, Arcade1up, telling ThinkUp that they're having financial issues, that they're restructuring the company, and that a continued 3% royalty, in their opinion, was not sustainable, and wanting to renegotiate that contract. And they likely threw out, hey, we can do flat fees, we can do some of these other things. We'll talk about that again up here. We'll mention that. That gets into it a little sooner coming up. But obviously, Mr. Cummings was coming there with the perception that this wasn't about their agreement, but more other ways in which they were going to, how their communication and flow would work without Scott in the middle. And instead, he's just stunned that, hey, they want to pull this um, royalty. So, you know, again, communication is so critical. Uh, They could have probably avoided some of this and actually had a productive negotiation had they communicated more clearly with ThinkUp and ensured that ThinkUp understood the situation before coming down there. If that was indeed his first interpretation that they were wishing to renegotiate the contract, you can imagine that would feel pretty blindsided flying down from New Jersey to Miami and then having to go through all that. Um, in what is essentially foreign territory, from the terms of ThinkUp. That's not their offices. You were in Arcade1up's offices. It says the meeting quickly ended due to the aggressive position taken by defendant. So he's saying he ended the meeting, in my opinion, from the statement. He's saying they were being very aggressive about needing to renegotiate. And he's like, we're just not talking about that anymore, and left. So on August 21, here we go, 5 days later, Disruptive sent a letter to ThinkUp notifying plaintiff that the 2019 Arcade1up agreement was being terminated in 30 days, blaming the termination on ThinkUp's refusal to renegotiate its royalty agreement arrangement and rumors of ThinkUp employees planning on discontinuing their work with respect to the Arcade1up Infinity Game Table products if the royalties were not paid. And of course, a copy of that letter is attached. Uh, yeah, so This is that letter. You'll see it's the notice of termination. And it says, "We appreciate you visiting Compass offices on August 16th to discuss the company's current situation and its go forward relationship with Thinkup." So they're telling them, they're reiterating here, their situation. They have a financial situation that they need to deal with. As Dora Devere and I explained at the meeting, the existing agreement is untenable for the company, meaning they just can't financially comply and move forward, is what they're saying. It's just unacceptable for them to continue with that existing relationship. So we are open to exploring other business arrangements with ThinkUp. Again, they're leaving the door open here. They want to work with ThinkUp to continue the company. As we see, ThinkUp seems to be the heart of Arcade1up. ThinkUp is the one who designing all of their products. Without ThinkUp, who's Arcade1up? John D was their licensing guy. What do all the other people bring to the table other than typical operational stuff? If ThinkUp is designing all your products, John D's grabbing your licenses, what is anybody else doing? And so without ThinkUp, without John D, how does Arcade1up even move forward? They've got to find suitable replacements. They got to find another toy company that can come in, or toy designer, product designer that can fill that hole. So very interesting. And it says they want to reach a new agreement if feasible with mutually beneficial terms. They want to keep cranking out new product. Let's come to an agreement. Um, as previewed during our meeting, that agreement could, for example, pay ThinkUp fees for certain specified services. So they're saying again, hey, if you perform specific tasks, we'll pay you flat fees. Regrettably, they communicated at our meeting that ThinkUp was not willing to enter into a new agreement with the company without inclusion of 3% royalty contained in the existing agreement. While Dora and I assumed you may reconsider that position and re-engage discussion, we learned that you or other ThinkUp employees subsequently told company, so that's Arcade1up employees on August 16th, 2023, that the ThinkUp was ceasing all work for the company immediately. So they're saying the same day that the meeting was held in Arcade1up's offices, that ThinkUp employees are saying they no longer work for Arcade1up. Accordingly, pursuant to Section 6A of this agreement, this letter shall serve as notice that the company hereby terminates the agreement effective as of 30 days of the date hereof, September 19th. We remind you that until the termination date, the agreement shall remain in full force and effect, and ThinkUp shall be required to comply with the agreement. Our understanding is the obligations under the agreement. Our understanding is that ThinkUp is currently in breach of such obligations by terminating the customer's access to a Dropbox folder containing materials to which the company is entitled. The company's request that ThinkUp immediately cure this breach. And of course, then they go into some of the provisions of the agreement that says ThinkUp needs to deliver them all kinds of books, sales information, design documents, etc. It says, also by this letter, the company reminds ThinkUp of its confidentiality obligations. So this is, you got to keep things confidential beyond the agreement. So I'll spare you reading all that, but it has to be pursuant. You got to keep everything quiet. And then as of the last reporting date, ThinkUp owes Tastemakers not less than 621,000 in advance royalties. So they've advanced ThinkUp more than $500,000, and the company believes, Tastemakers believes, that the following commission termination period, the company's statement of settlement calculations will demonstrate that ThinkUp will still owe the company a substantial amount for overpaid advance royalties. Nevertheless, because of the company's longstanding relationship with ThinkUp, the company is willing to waive any such amounts owed by ThinkUp to the company in exchange for the general release in favor of the company contemplated under these sections of the agreement. So here, Arcade1up, Tastemakers wants to be released from all liability and all obligations under the contract. In exchange, they'll waive what they perceive to be a $621,000 debt owed by ThinkUp to Arcade1up. However, if ThinkUp does not deliver the company agreed release in the form acceptable of the settlement, following the commission termination period, the set-off period in accordance with Section E of the agreement, and thereafter diligently pursue payment of any and all amounts owed. So basically, they're saying they're gonna collect this $621,000 if you don't give us this waiver. And then, as noted above, the company remains ready to and willing to discuss a new go forward. So even though they do say all these threatening things about you owe us money, we'll go after you if you don't give us a waiver, they turn around and say, but we're still willing to work with you. We still want to discuss going forward with an agreement with ThinkUp that is on mutually acceptable terms. We are open to, among other things, exploring a service based flat fee arrangement. We look forward to continuing these discussions over the next 30 days with ThinkUp and invite you to reach out to me. And here you see the M. Shea person who appeared at that meeting and who works at this Think BRG, which is that um, uh, business consulting firm. And as of course, you know, this is public record, which is why her information is in there. You know, don't be dumbasses. Like, don't be emailing them, don't be calling them, just get yourself in trouble. So I'm getting off this for now. But yeah, she's doing her job. She's listed here as chief restructuring officer and she's the one who signed this letter for disruptive products. So now we are back to this agreement, and we just went through, of course, Exhibit C, and then he says, now fast forward, we're in this year, right? January 31, 2024, Disruptive sends a follow-up letter attaching what was described as a settlement of final commission due and general release seeking to secure plaintiff's full waiver and release of its rights and claims against defendant for a lump sum payment of $213,698. So let's read that again. Disruptive sent a follow-up letter attaching what was described as a statement of final commissions due and general release. So again, they're saying sign the release and we're now going to pay you. So we think we still owe you $213,000, not the 620 that they alleged in their one email. But here we are 6 months later, right? Actually, that was August. So now we're in, yeah. So we're basically September, October, November, December. We're 4 months later from those threatening emails, and now they're basically okay. Based on all that Q4 sales, the 60-day period after our agreement terminated, we do actually owe you $213,000, which speaks to the strength of those Q4 sales. And a copy of that letter is attached. In Exhibit D, the payment represented royalties, commissions on orders received through the termination date, which have been owed to ThinkUp regardless. The report attached to the January 31, 2024 letter once again failed to provide adequate detail in order to determine its accuracy, even through the alleged termination date. So, getting into the accuracy, I don't know if he's alleging that they should provide detailed sales numbers, as in like the number of cabs, what products, etc. Again, this is where representation would have helped ThinkUp in the negotiation of this agreement, because there is no provision in the agreement that gives ThinkUp the right to audit the numbers. That's the key word. They need the right to be able to audit, or some other obligation by Arcade1up in that agreement, or Tastemakers, that would provide them that audit annually or whatever, so that they could verify the numbers. Instead, the agreement specifically states ThinkUp only has 30 days to dispute a payment amount. So if they're not being proactive, they're waiving their rights to come back on those invoices and say that they've been paid improperly. So the obligation here in this agreement all was shifted to ThinkUp. And because ThinkUp didn't bring in representation to represent them, they didn't fulfill their side of that agreement. And now they're coming back saying, hey, we want to see all that stuff. I think that's going to be an uphill battle for them. But let's take a look at the statement of settlement, because there is some very interesting financial data from Arcade1up in that piece. So here you go. Statement of settlement, overnight mail, blah, blah, blah. Jerry, as you know, the agreement was terminated September 19th. Pursuant to the agreement, hereby is delivered to Thinkup a statement of settlement of the commissions earned but not yet paid based on the information currently available to the company. A general release attached to be executed by Thinkup and returned to the company as a condition pursuant to any settlement check. So here they're saying how much we owe, but you're not going to get it until you sign the waiver that they've asked for. And in connection with the statement of settlement, because of the issues addressed herein and lack of complete data yet to be available. So they're saying they'll still get some information on returns, etc. Um, that they are going to deduct expense deductibles from net sales under the agreement because of the issues addressed herein and the lack of complete data relating to various returns, chargebacks, and other expenses deductible from net sales under the agreement for the period in question. The company reserves all of its rights to revise the calculation set forth. So they're saying if more come in that lowers that amount, they're going to do that prior to any settlement check being payable and delivered to ThinkUp in accordance. Deliver all, and of course you've got to deliver them all remaining books. These are all called out in the contract itself when it's terminated. In order to get that final payment, ThinkUp has to give them all that information. So the statement of settlement is also subject to revisions to address blah blah blah. Please be further advised that nothing in this letter or the attached statement of settlement should be construed as acknowledging or omission of the company of any liability or any amounts owed to ThinkUp. So let's get down here to this fun stuff. And let me zoom in here. Where's get a better look at this. So this is this is our ledger statement of settlement. So right away we see some impressive numbers. So in Q1 and Q2 of 2023, Arcade1up had sales of $11.6 million. July 2023 sales alone, 9.5 million. So you can see they do very little sales in Q1 and Q2. It only hits in July mid-year where Arcade1up numbers begin spiking dramatically on the build up to Q4. So in July, they basically double their prior 6-month sales totals and bring in another 9.5. In August, so the first 3 weeks of August, they do another 10.4 million in sales in just 3 weeks. The next 4-week period, which is the time up to the termination date, they do another $14.7 million in sales. Let's see, scroll back over so we can read the rest. It says sales to termination period. I'm not sure what this is. It says which, and then there's this line for 7.9. So whatever which is fell off this and is another 7.9 million in sales. Then they have this solution to go canceled orders, solutions to go not yet sold through but not paid. Another 10 million. So 4.5 and $10 million there on whatever this solutions to go is. So all in all, up through the period, not even the full year, up through the period in which ThinkUp would be due royalties, that 3% royalty fee, Arcade1up had a total of $68.9 million in revenue. Now we begin deducting from that revenue. So this line item here is this 8.2 million, call it 8.3 million. This is a reduction, and that includes a write down for closeouts and other items that essentially reduce that gross sales number. And then they also have a markdown category. So these are the sales, right? And that's going to reduce another $6 million. So you have total net sales or what is essentially the first 3 quarters, almost the first 3 quarters of 2023 of $54.4 million dollars, and total commissions to Thinkup of $1.2 million dollars. So pretty interesting. Those sales numbers are pretty interesting. That 68.9 million in revenue with net sales of $54.4 million dollars for the first 3 quarters of 2023. Arcade One Up is generating a ton of revenue, yet they still are having financial troubles, which is really interesting. So it makes you wonder about their debt obligation and where all that money is going. Of course, here's some markdowns broken out. This is showing you, a Kokum markdown for 2022 of $3 million. Kokum buyback inventory, so stuff I guess they sent back to Arcade One Up, or Kokum buying it back from from retailers, and then other markdowns, co-op advertising. So co-op advertising is if you run, say, the Brick, right? I think the Brick produces print ads. Um, Featuring Arcade One Ups, they may split some of those costs, offering certain payments so that retailers will go out and advertise uh, Arcade One Up's products in their mailers, their and other marketing sources, TV commercials, online ads, et cetera, et cetera. So we've got again the payments catalog sent to Thinkup, and so it looks like the agreed to term is $128,000 a month. Then you see when they have the settlement there in the third month, and then they continued paying 120 for a total of $880,000. And once all that's brought in, it says we still owe you $213,698. Pretty interesting on those numbers. So I did want to share those. And we will jump back to the filing. Uh, Once again, says provide FATIC. We did that. So in recent press release, and we've talked about this a ton on this channel. Recent press release, Arcade One Up was noted as having been named Best of CES, referencing the annual Consumer Electronics Show in 2022 and 2023, and becoming the fourth largest brand in gaming hardware, and referencing the Infinity Game Board and Infinity Game Table as being game changers in their industry. The products developed by plaintiff and sold by defendants have generated sales in the hundreds of millions of dollars, and in all likelihood continue to generate substantial sales revenues in the future. It says, despite the very idea Arcade One Up product lines were thought up by Mr. Cummings and his team, despite the countless hours and every detail, product reliance on defendants' promise to pay Thinkup. So this is where I'm not going to read through all this. Basically, Thinkup says, look, we deferred all other business in order to focus on Arcade One Up with the agreement that you'd be paying us this 3% forever. And then now they follow up and say, due to the magnitude of the work, Arcade One Up Infinity lines of products and the anticipated revenue, Lifetime Thinkup significantly curtailed the pursuit of new business from other sources and focused energy purely on the success of the products being developed with Tastemakers. As a result of Tastemakers' sudden termination of the relationship, Thinkup was forced to lay off its entire staff, with the exception of Mr. Cummings and his immediate family members. So basically, Arcade One Up severing the relationship cost everyone at Thinkup their jobs, um, which is a shame. I think that, as we know, they were trying to get the company back on track by doing that shuffle shot, and unfortunately, that did not work out for them, which is a shame. Thinkup obviously made some great products that we all love, so you hate to see something like this um, happen. See, it says, so here we get into the accounts. So first is accounting, and I'm not going to read all these, but basically, this is what they're asking for and what they say they're owed. So plaintiff is entitled to an accounting of all revenues of Tastemakers and Disruptive of Arcade One Up and Infinity machines from 2018 to present. So they want to see all sales of the Arcade One Up products, including the Infinity game boards. They believe that the review and analysis of such reports will reflect that defendants owe plaintiff millions of dollars in royalty payments up to the date prescribed in 2019 in the agreement and millions of dollars subsequent to that date. They also allege breach of contract. So they're saying despite the agreement, defendants have failed to pay such monies to Thinkup since July 2023, and upon information and belief, failed to pay accurate and full royalties for sales prior to the date prescribed in the 2019 Arcade1up agreement and for sales made subsequent to that date. So again, they're saying you owe us money after the termination date because we believe the royalty extends for the life of the product. And we know Arcade1up didn't issue any additional payments after July of 2023 because they believed they needed to renegotiate that contract and that Thinkup actually owed them. And then based on strong later sales, it turns out they still owe Thinkup, but they're waiting for those documents to issue that final payment. That's essentially what's happening there. And it says Thinkup has suffered damages in excess of $1 million as approximate result of defendants' breaches. So the third count in their lawsuit is quasi contract and unjust enrichment. And it says the parties never formalized the agreement to govern the royalties for the Infinity game table and the games Thinkup developed for the game. So this is a strong statement. They're saying we never had an agreement on that product. And so you owe us lots of money from that. You just enriched yourselves and you never paid us. Again, we'll take a quick look at the agreement and see that this is not accurate, that the agreement that they signed in lieu of other documentation showing otherwise absolutely gives Arcade1up or Tastemakers the rights to the Infinity game table. Um, or those sales under that agreement, I should say. With respect to the sales of the Infinity game table line of products, defendants have breached the understanding between the parties that a formal agreement would be forthcoming, providing Thinkup with at least 3% royalties for the sale of each unit for life, at least 3% of the royalty, the revenue from the sale of new games developed by third parties, and a 70-30 split for the sale of apps from the game store Thinkup designed. Again, they did not provide any evidence to back up their understanding of this relationship. There's no emails, there's no nothing that says that they've provided us proof that that is going on. So definitely would be interested in future exhibits that may show that. Until then, we have nothing to go by. It's just them saying. And so here, therefore, they're gonna. Wherefore, Thinkup demands judgment against defendant as follows: defendants be required to provide a detailed accounting for sales of the Arcade1up consoles and accessories, the Infinity Game Table, Infinity Game Board games sold through the release game store, and any associated accessories. So they want a detailed accounting of all Infinity Game stuff. That defendants be required to account for and pay over to Thinkup any and all of Thinkup's damages sustained by Thinkup by reason of the acts complained of in this complaint, including but not limited to Thinkup's lost profits, including an assessment of interest of damages so computed and the damages be enhanced to the maximum available under applicable federal and state laws. So here they're saying not only do you owe us what you should have said, but we have damages. The company has failed, our revenue has dried up because we weren't able to seek other business as a result of our agreement with you, and therefore you owe us much, much, much money. And then C, Thinkup be awarded punitive or exemplary damage under New Jersey and New York law because of the egregious, malicious, and tortious conduct of defendants complained herein. Again, saying now we want above and beyond damages, proven damages. We want you to give punitive damages, which basically gives you, in most states where punitive damages are allowed, a virtually limitless amount of money can be alleged. So this is how they have forced shut down other companies by throwing on billion-dollar damages, things like that, that basically no company could actually pay, and it ends up getting them shut down. So they're asking for punitive damages, albeit those are rarely actually distributed. They're asking for it. Standard procedure, I think. And that any revenues defendants receive for which it has not paid 3% royalties to ThinkUp, and any revenues received by defendants for ThinkUp work once is purported to terminate ThinkUp be disgorged and awarded to ThinkUp. So they're saying we need all those revenues that you haven't paid us that we allege you still owe. And E, that ThinkUp be awarded damages equal to the revenues by defendants which were unjustly enriched. So now they want damages on all that revenue. ThinkUp be awarded its reasonable attorney's fees. That ThinkUp be awarded pre-judgment and post-judgment interest. So now they want interest being charged from the dates that they weren't paid. So again, racking those numbers up. And that ThinkUp obtain all such other further relief as the court may deem just and equitable. So that is the full text of that filing. And let's just jump in really quickly. We've talked a lot about a lot of these sections in this agreement from 2019, but there are a few key things I want to just show because they're central to the claims that ThinkUp is making. This is just saying July 2019 is defining the parties. So here we get into the duties, and it says a company contracts with developer. In this case, the company is Disruptive and Tastemakers, and the developer is ThinkUp. So the company contracts with the developer to serve as a sales developer for company under the terms thereunder set forth to serve as the company's lead product development and advanced research and development team. So here they're saying you are our primary developer of products, ThinkUp, and you're our R&D team. You're responsible for all that stuff. You're the primary person. And then ThinkUp agrees to provide product development and related services with respects to the company's Arcade1up brand and products and multiple other brands and products. So this is the provision, I believe, in my opinion, again, not an attorney, that really puts ThinkUp in a pickle with regards to their claims on the Infinity game table, because this provision opens up all other brands and products. It encompasses not just Arcade1up, but Infinity game table, Infinity game board, and anything else they might think up and cook up. This covers all of it, all other brands and products. That is a key provision of this agreement that ThinkUp signed. We'll jump down here, and it says um, that the developer warrants and represents that he presently does not intend to provide any development or other services. This is essentially a non-compete, so I just wanted to share that that ThinkUp is prevented from working with anybody else during the term of this agreement, and that the company will give not less than 90 days prior written notice of his intention to represent or sell any such competing or conflicting product lines. So they have to alert Arcade1up if they are going to do something like that. We get down to parties agree that the developer is an independent contractor. So again, this is important when you talk about who owns intellectual property. Uh, in an independent contractor relationship, the contractor themselves always retains intellectual property rights unless specifically spelled out in the contract that those are to be transferred to the contracting company. In this case, I find interesting, I did not find that provision. So I'm curious uh, why ThinkUp, in part of their lawsuit, one of the tactics I might have at least pursued, again, maybe they tried this. They definitely did when they tried to fight the trademark infringement, right? They tried to object. So maybe they're holding that back. But that's the first thing I would do is I would attack their trademarks and say, that's our intellectual property. You can't run around calling yourselves Arcade1up. You can't call your products Arcade1up's Infinity game tables. You can't use the designs that we gave you because that's our intellectual property. And you must cease and desist using those moving forward. So maybe they'll pull that out if this lawsuit is not successful. But it's very interesting. I found no provision that I saw that would transfer the ownership of all of that IP to our Arcade1up. Let's see, skip down here. commissions, which we read this in the thing. This is where it defines the 3% royalty. We also covered this. It talks about the payment schedule for those royalties, and you can see some of these right here. Um, Trade secrets. This is more confidentiality language. We get down here to C. Says in the event of the termination in any manner, developer agrees to deliver. So this is again talked about in there. This is the provision that actually requires them to give all of the books, records, notes containing account lists, types, and kinds of raw materials used by company, the supplier, and cost therefore manufacturing process and duplicate invoice or statements pertaining to such account lists, the schedule of sales calls upon them, code books, price lists, product manuals, and any other information of a confidential or secret nature applicable to the company. So this is where they just want all the documentation around the products that were developed by Thinkup for Arcade1up, and it is part of the termination uh, clause. And the amount of actual potential damages, so this is an important one, right? Potential breach or threatened breach of any of the terms of this agreement will be inherently difficult to determine with precision. And furthermore, any breach could not be reasonably adequately compensated in money damages according to any breach by developer of any of the provisions. So this is Arcade1up. What's happening in this provision is Arcade1up is carving out their indemnification clauses. So they're basically saying, and this is again fully one-sided in this agreement, that if ThinkUp breaches the contract, Arcade1up can basically sue them limitlessly. So typically, what you would see in an agreement like this is both parties would indemnify the other and try to limit as much liability as possible under the contract. Typically, you might limit to any fees paid, right? Like you can't go beyond what you've paid me in royalties, right? So and then again, you might even limit that, say royalties within the 30-day period of being notified of such breach, and only after giving a chance to cure the breach. I mean, there is no language in here protecting ThinkUp um, from Arcade1up if Arcade1up alleges and can prove that they breached this agreement. So very very one-sided. Um, and it says the developer of any provision set forth will result in immediate and irreparable injury to the company for which the company will have no adequate remedy at law. Company thus will be entitled to injunctive and other equitable relief to prevent any such breach or threaten breach and or adequately remedy any violation of the provisions set forth in this section without any requirement to post bond. Companies retor- resort to such equitable relief will not waive any other rights it may have to other damages or other relief, and companies shall be entitled to its reasonable attorney's fees and costs incurred in pursuant to the set. So again, all one-sided. This all is for Arcade1up. So now we get into the termination, and this again is uh, another mistake made by ThinkUp, in my opinion, that they really should have had representation on. And the term termination and settlement, it says, unless otherwise terminated under another provision of this agreement shall remain in effect until terminated by the company on at least 30 days prior written notice of the effective date of termination. At termination, developer will continue to receive commissions on all Arcade1up machines which have been completed. However, it will not be entitled to commissions on machines that are in the development stage and not completed at the time of termination. So, again, the agreement here states specifically that Arcade1up can terminate the agreement for any reason whatsoever at any time. They just have to provide 30 days written notice. That is bad, especially if you're ThinkUp and your entire company is all in one basket with Arcade1up. You this is um this is so one-sided. Barry, don't sign an agreement like this. I have to tell you, this is very one-sided. Um, man, just Wow. Get representation. Make sure somebody's looking out for you because, man, what a mistake. It also states that after termination, they only have to pay for the Arcade1up machines. It doesn't mention the other products suddenly. So um, they've limited their what they have to pay out. So they'll only pay you for Arcade1up machines. Any software, things like that, that seems to not be included. This is I also found interesting. I just kind of threw it in here, but here Arcade1up has gone above and beyond and specifically said pointed the principal of Thinkup, Jerry Cummings, and they put in a provision here that says if at any time during the term Jerry Cummings dies, becomes disabled, or ceases to be active in the business as the president of Thinkup Inc., company shall have the right to terminate this agreement at any time upon written notice to developer. Notwithstanding the foregoing, in the event of termination of this agreement due to the death of Jerry Cummins at the option of the company to be exercised in writing by the company within 30 days after the developer's death, the company agrees to continue paying commissions to developers estate for 12 months after the date of the developer's death, or company will directly retain developers' employees to provide the services and will continue to pay such employees during such 12-month period so long as they continue to provide services to the company that are satisfactory to the company. For the purposes of this paragraph, disabled means that Jerry Cummings is unable to run or administer ThinkUp's business for a period of 90 or more consecutive days or 120 days in any 12-month period. So so here they're basically saying Arcade1up believes Jerry Cummings is the company, and without Jerry Cummings, ThinkUp isn't a company. That he is the brains behind the operation, and nobody else there can step in for him if he is uh, deceased or disabled. And then he gives there's a little bit of insurance in there that says Arcade1up can choose between several different options here. They can choose to just continue paying commissions to the developer's estate, or they can go ahead and hire the employees for 12 months and basically continue to operate the company as though it's under Arcade One Up, and they can continue to do so indefinitely, I guess, if they want to. But very interesting with a minimum of 12 months, so they can choose one of those two options if Jerry were have to have died or uh, become disabled. Very strange provision. I mean, you do find things like this when the things are the brain, in creative stuff. But I would imagine ThinkUp has more creatives than just Jerry Cummings, but maybe they don't. Maybe he is the one and only brainchild of their products. We'll jump down to this, of course, termination of cause. Um, says failure to perform developer services in a manner satisfactory to the company after having been given written notice of the specified or unsatisfactory performance and reasonable opportunity of at least 30 days to correct such performance. So this is, let's see, what are we under here? Term termination. So these are the ways in which they can terminate the agreement. But the number one gives them basically carte blanche. But under Section C, it says the company may terminate developers' retention as provided under this agreement at any time for cause. So they're saying they don't even have to do the 30 days thing if they have cause. They can just get rid of it. Uh, and this is where they get out of all that stuff. So basically, all this provision C does is protect them and give them a way out so they don't have to pay the remaining royalties. Another way to get out is the developer shall be entitled to commissions in accordance with the provisions of the agreement on orders written up to the effective date of termination or expiration or such other length of time as agreed to in writing by the company. All such commission orders shipped within 60 days of the order date shall be considered earned in accordance with the foregoing. So any order that they received before the effective date that but may not have shipped, as long as it ships within 60 days of the original order, even if it's after the effective date of the termination, should get paid out. Developers' acceptance or retention of settlement checks shall release and discharge. So if he cashes that final check, it discharges and releases Arcade1up, Tastemakers, its directors, officers, employees of any claim developer may have in connection with this agreement. So even if Arcade1up sent taste or think up a check. If they cash it, they're automatically holding them, releasing them from all claims. So there you go. It says developer acknowledges company's ownership or license to use its names and logos. Developer agrees to use company's names, trademarks, designs, logos only for the purposes required in this agreement. Developer shall not do anything. That's basic stuff. Here's the indemnification clause. Developer shall indemnify, save, and hold company harmless against any and all claims, losses, damages, suits, actions, expenses, including but not limited to attorney's fees and liabilities arising out of or relating to the contact of the developer or any of its agents or employees. So this is just indemnifying Arcade1up if something one of the ThinkUp's employees does creates a liability for them. It means uh, ThinkUp has to handle all that. This is the agreement we talked about before. This just says uh, the jurisdiction and governing law for this agreement is in New York, and it also states that all disputes under this agreement must occur in the jurisdiction of New York. So, uh, let's see. It says New York County and/or federal courts located in such state or county in any proceeding to enforce this agreement and agree not to interpose any objection or defense based on lack of personal jurisdiction or proper venue in such proceedings. The developer and company consent to the exclusive personal jurisdiction of the courts of the state of New York. Yeah, well, and not to interpose any objection or defense based on the lack of personal jurisdiction. So basically, it has to be in New York, and you can't object otherwise. Each party agrees that services in any summons complaint or other process proceedings may be made to such party outside of the state of New York with the same force and effect as made within the state of New York. Each party also waives trial by jury. So they're asking for a trial by jury, but that's already been waived. Their filing in that lawsuit specifically is for trial by jury, but here in their agreement, they've already waived that. Personal services of any summons, complaint, or other process in any such action or proceeding and agrees to services. Blah blah. So that's language is confusing. I would need a legal scholar to indeed confer because this makes me think that hey, you can't object to the jurisdiction, but at the same time, you both agree that that's the principal jurisdiction and all laws governing there. So I think this is just saying you can own you just can't for personal jurisdiction. You can't say, "Hey, I live in Jersey, so therefore, our business is located. You have to go to New Jersey." I think it's still saying it has to be in New York. But again, any of our legal friends who watch the show can comment on that. Um, Interpretation of the agreement. In the event that any misunderstanding, ambiguity, dispute concerning this agreement provisions or their interpretations, no rule of construction shall be applied that would result in having this agreement interpreted against either party. The language of all parts in this agreement shall be construed as whole according to their fair meaning and not strictly for or against any party. The headings provided in bold are inserted for the convenience of the parties and shall not be construed to limit or modify the text of this agreement. So again, this goes back to this final sentence. It's about where it calls the royalty a commission as the header. That it doesn't mean anything. And of course, there's our signatures from our principals. So there you have it. Uh, all the current filings in ThinkUp versus Disruptive Products, aka Tastemakers, their claims, right? We developed all your products, we developed all the royalties, or are the sorry, all the intellectual property. You didn't pay us out accurately. You breached our contract. Arcade1up had to restructure due to financial reasons. They could no longer meet the obligation under ThinkUp's agreement that they had with ThinkUp and sought to restructure. ThinkUp didn't want to restructure, therefore, Arcade1up terminated their relationship with them. That led allegedly to ThinkUp having to lay off its entire team as they could no longer make payroll and just keep a core group of immediate family as members of and employees of ThinkUp. Um, so quite a mess. And of course, the big thing in there we saw, you know, 3/4 year revenue from Arcade1up of what was it, $68 million, somewhere in there. Yeah, sales of $68.8 million, 54.4 net sales. And so some interesting information that we were able to get out of this filing, uh, really proof Arcade1up is having financial concerns. We've got real revenue numbers which show that Arcade1up is making or at least having more sales far higher than anyone, uh, I think would have imagined. uh, so the idea that they're a small company, I think, some gotta go out the window. I mean, you're doing that amount of sales. Um, yeah, I mean, maybe it was being run as a small company, but, that is a huge amount of annual revenue. So even if you take the royalties at face value and you're looking at Arcade1up over the life of Arcade1up has generated $333 million worth of sales, that's pretty significant for a company that's, you know, 6 years old at most. And clearly based on last year's sales spiking up dramatically. Um, but now I think we also have a glimpse as to why they are completely quiet. Not only are they in the midst of this lawsuit and can't uh, say much, but they're really limited on what they can release because if it wasn't already in the hopper, they don't have anybody to develop a new product. So why would anything new come out until they get another company? And they may have one by now, and they're working on new designs and development. But until they have one, how can you release anything? And maybe that's why we're hearing these weird cabs at Costco. You know, I don't know. I don't want to go into that too much. We've talked about those, but maybe this is the first release of new cabs from a new design firm. Um, but who knows? I mean, it could just be, if they don't have somebody and they don't have Thinkup and specifically don't have Jerry Cummings, who seem to be the ones that responsible for all of this stuff. What do they have to sell, right? And so legally, it looks like they think they have the right to continue pushing the Infinity game board without fear of, um, having to pay royalties to them beyond those sales numbers. And what's been out there, they don't think they have to sell them, and they're don't have anything additionally in the hopper that they're looking to release right now. So very interesting, and I think gives us a lot of insight into why Arcade One Up's been quiet and the inner workings of that company. So if this is your first time joining us, normally we just talk Arcade One Up, we talk retro games, we talk toys, we just have a good time hanging out with everybody talking these things. We talk about the business itself somewhat and the business of home arcade, which is always fun. So if you've made it this far into this video, I truly appreciate. This was a lot of reading, a lot of going through these things with you. And so I hope you learned something. Drop a comment below if you have any questions. If you are an attorney, definitely um, let us know if my uh, understanding is wrong in your opinion on anything. Again, this was all for entertainment purposes. I am not an attorney. You should get an attorney and seek real legal advice. If you've learned nothing from this, hire your own attorney for legal advice. Don't trust other parties. Don't trust people on YouTube. Get your own legal advice and legal opinions. And so I'd appreciate if you'd smash that like button and click subscribe if you want to join this conversation in the future. If we see any updates, I will be sure to drop another video so we can talk about this. And I look forward to talking with other people coming up about this case. And as always, till next time, have fun.